I'm going to live.
Sorry?
I'm going live, sir, on YouTube.
Yeah,
Yes, you
please,
are.
please.
Yes, you are live, sir.
I'm live, right?
Yes.
Okay, thank you. So today is lecture number 2. And if you recall that yesterday, when when we finished, we were at this slide. And if you remember what we started that when we plan our research, we are at a conceptual stage. And at the conceptual stage, when we start defining our subject, when we start defining our problem, what we generally do is we do a literature search. And why do we do a literature search? Because we do a literature search to find out what is the sort of state of art on, before we start our work, so that we define our work in the context of what is already known. Correct? And when we do a literature search, we generally search, journals, books, and other general literature. What I mentioned to you yesterday was that you must also search patent literature, because what I mentioned to you was that in certain fields of technology, science and technology, today, whatever is filed as patents and those which are available in the patent literature, most often those are not published in journals or in books or in papers or presented elsewhere, which means that if you do not see patent literature, then you are probably working on only about 40 to 60% of the literature that's available in the world. Whereas, and therefore, the chance of you repeating what is already done is very high. Number one. And number two, we ended yesterday by saying that, moreover, if you're doing some work and you have not looked at patent literature also, then when you want to do technology transfer and you want to commercialize or do anything like that, and if it is caught at that point in time that this is already there in the patent literature, A, the work goes waste, and B, it will never be commercialized. So this is something which is very, very important from that point of view. And therefore, whatever be the case, that each and every one of you who's doing their research must know how to search patent literature. And that is some training that we will have to, instill and some skill level into you to do that, because that is an integral part of your research. And if you don't do that, then your work is fairly incomplete. So it's only that way. So therefore, when I say literature search, I mean not only journals, books, papers, lectures, and everything. I also mean include patent literature into it. That is point number one. And point number two is before you start your work, and as you go on in doing your work in time, you must go on looking at these literature continuously every week, and you must be current to that week. And therefore, if any publication comes in or any patents are filed and that publication comes in, then you must readjust your working and everything to that currentness. Normally, our researchers in India are not doing that. That is my observation. And it is something that I want to, continuously. Therefore, you will see in this slide as a formal documentation, number one, and updating techno-legal information continually. Every week you must update this particular information. Otherwise, you may be falling back, and I will show you consequences of this at a later stage. So this is something which is very, very important. I couldn't overemphasize on this particular point as far as we are concerned. So this is something that I would like each and every one of you to keep in mind as we go along, and something that you ought not to be, taking it lightly, because you must ensure that you do that in a very serious manner. Now, any questions at this stage, you may put it in the chat box, and I'll see it and respond. Okay, because as I told you, this is a subject matter which needs a lot of discussions, needs a lot of debate, and most of you are probably not familiar with it. Therefore, there will be questions. So start doing. Does it restrict others? Does it restrict others of doing betterment of that part? I've not understood. What is the betterment of that part means what? Whoever raised the question, can you clarify, please? Yeah, from chemical, yeah, Jui Datta. So can you just clarify? I would suggest, why don't you just unmute yourself, or can you unmute Jui and let Jui ask the question so that you can clarify before I proceed further. Can you unmute her, Jui Datta, please? Can you unmute? I don't have a question. Any question? Okay, you don't have a question because apparently, oh, sorry, if one invents some part, if one invents some parts of machine and patent it, does it restrict others from doing so? Yes, it does. It does. Ritvik Majumdar, it does. Okay. Any other questions at this stage? Okay. So we'll continue and you can go on asking your questions and we shall respond to them as we go along. Okay. Now let's go to the next slide out there. And then the next slide, as I will put in, you will see here that I will now like to go and define what is a patent. Because we told you that today onwards, for at least 3 lectures, I will be concentrating only on patents. And which is very important for us to realize what is a patent. Now, when we say what is a patent, I put a very simple definition. A patent is a grant. What is the meaning of grant? Grant means that it gives. Somebody gives, somebody gets. It's a grant. It's a formal giving. It's a formal giving and a formal, taking. So that is a grant. Okay. So that's a formal grant. So now it's a grant given by whom? Sovereign or state. That means an independent country. Sovereign or state. It could be a kingdom, independent kingdom, or could be an independent country. So sovereign or state. So who gives you the grant? It is the government that gives you the grant of a country. If whom does it give the grant to? It gives the grant to a person. Mind you, it gives a grant to a person. And here the word person, means not only a natural person, but it also gives it to a person what is known as the legal person, in the sense that an organization, like, for example, DAE, Department of Atomic Energy, is an organization. And this Department of Atomic Energy, which is an organization, or a university, which is an organization, or a research institute, which is an organization, or a company, which is an organization, okay, is given the status of a person, so that company also becomes a legal person. So it is given to a person. Gives what? Gives an exclusive right. If that right is given to you, and that is only for you, that is exclusive right. Now, when it is given as an exclusive right. Now, once it is given as an exclusive right, that is one part, exclusive right. What, given that right for what? That right is given for an invention. It is not given for a poetry. It is not given for, taking a photograph. It is not given for a sculpture. A patent is given for an invention. We talked about it. Now, it is given for an invention. For how long? There is a limited period, not forever. That limited period is 20 years from the date of filing if you get the grant of the patent. Okay, so it's only 20 years from the date of filing. So it's for a limited period. Now, then, and how do you get it? It is in exchange for disclosing it. Where if you write a paper, a publication, do you get a patent? Answer is no. So you have to disclose it in what? In a patent specification. Therefore, you have to apply for a patent in the form of a patent specification. A simple publication does not give you this exclusive right. So to get that exclusive right, you need to apply in the form of a patent specification. Where do you apply? You apply to the Indian Patent Office if you're in India. So you have to apply it as a patent specification. And how do you write a patent specification? You have to write a patent specification in such a manner that a person trained in that art can reproduce that invention. Which means that if I'm writing, if my invention relates to, say, genetic engineering, then I must write it in such a manner that somebody else who is trained in that area should be able to reproduce whatever I'm saying. That is very important. So that's the way a patent specification is written. And what does this give you? This grant, which you get, the right, the exclusive right you get, it is a negative right. It's a very interesting type of right. It's a negative right. What do you mean by negative right? It means that a patent gives you an exclusive right to exclude others from using the patented invention without your permission. It gives you an exclusive right, and that exclusive right is given to you. As I said, that exclusive right is given to you. How is it given to you? That exclusive right is given to you to exclude others from using that particular invention without your permission. So you become the exclusive owner, and that exclusive owner who is there can stop others from making or using or selling, that particular invention. Now, if anybody wants to do anything with that invention which is patented by you, then they have to come to you and take permission. If they don't take permission, they cannot do that in this. So therefore, this is a negative right. It gives you the right to exclude others from using the patented invention. Now, can you, as the owner of the patent, can you, as the person who has got the patent, can you use it? So you can stop others, which is a negative right. Question comes in, can you use it? Just because I can stop others, does it mean that I can use it? Answer is not necessarily. And why it is not necessarily? Therefore, it says in the slide that the owner has a qualified right to use the invention, which means that if my invention, if whatever is the result of my invention, if that is governed by any other regulatory aspects, then unless those regulatory aspects are cleared, I cannot go and use my invention and go to the market, go to the public. What is an example of this? For example, if I've created a new vaccine or I've created a new drug, I get a patent for it, but I cannot go to the market and use it till I have cleared all the regulatory requirements and regulatory formalities. But can anybody else use it? Answer is no, because I have the exclusive right on that. And therefore, I can stop everybody else from using it. But can I use it? I can only use it after I get all the regulatory clearances. So similarly, if you're doing in automobile, you're doing in many other types of fields, and if there are regulatory restrictions, then you have to meet those regulatory restrictions, and only then you can use this particular your own invention which you have patented. You can't use it otherwise. Now, here is a very interesting question of a negative right. Now, do you people have any question on this understanding of what is a negative right into this out there? Any questions at this stage? Any questions at this stage? Any questions? Can anyone register and apply for a patent or an equipment technology development? No, if you have already published, you cannot apply. Question which was asked by Pankaj Kumar Saini. No, if you have already published it or anybody has published it, you cannot apply for a patent. You know, I would so is there any are you with me? Because I find this silence to be rather strange. I'm not used to addressing people in total silence. So either people should be active in the chat box, or get yourselves unmuted so that you can speak with me and I get some response from you. Otherwise, going back and forth from the chat box becomes extremely disturbing during the lecture. But if you ask me a question, I can always stop and respond. So we'll need to look at how to really do this. Okay, so let's go to the next part. But I would think that we need to be a bit more active in these type of lecturing, because this is a subject you cannot be a passive listener. You have to participate with me. And if you don't participate, then you will not get the best of what I'm saying. Okay, something that because when I lecture to students in the university, what is that? Somebody asking? No, nobody's asking a question. Okay, so that is what I am coming to. So let's come to the next slide. So in India, the patent law, which is at the moment in force, that patent law is called the Indian Patent Act 1970 as amended in 2005. So that is the Patent Act. Now, according to this particular patent law, which is prevalent in India, there are certain questions that we need to respond immediately. And the first question that we need to probably understand and appreciate is, how are inventions evaluated in India for patentability? And the first question is that, is any and every type of invention patentable in India? Every type of invention is patentable? That means that can any type of invention, right? Can it be patented in India if it's an invention? And that is a question. Before we go into nitty-gritty details, we must first look at whether there is any restriction on subject matter. For example, I'll show you that the Indian Patent Act says any invention related to atomic energy is not patentable in India. So if you are doing some work which is related to atomic energy, not if you're doing it in VRC or anywhere, but if it is related to atomic energy and it gives you certain clauses, certain sections of the Atomic Energy Act, that if it falls within those sections of the Atomic Energy Act, then those type of inventions are not patentable in India, however wonderful that particular patent may be, that invention may be. So you need to look at that aspect very, very clearly. So that is one aspect. But there are many other aspects which we'll need to look at to first assess that the type of work which I'm doing, is it patentable in India as a subject matter, before even going into nitty-gritty details of that invention. Then after that, so that becomes the filter number one. And filter number two, that if it goes through filter number one, that yes, the subject matter is patentable in India, then the next question will be that, well, if it is examined, because if it is not falling within the subject matter to be patentable, it will not even be examined. It will be thrown away straight away by the patent office. But if it is, it goes through that yes, it is in principle patentable in India because the subject matter is patentable. Then what happens? It goes through a second filter. And that second filter has three parameters. And those three parameters those three parameters are called novelty, inventive step, or non-obviousness, and whether the invention is capable of industrial application or whether it is useful. Now, it must satisfy those three criteria, and if it satisfies those three criteria, you get a patent. So it must go through these two filters. And therefore, as far as we are concerned, therefore, it goes through filter one. And if it goes through filter one, so I put in inventions through the filter one. And then whatever are not inventions within the meaning of the act, because the Patent Act says following are not inventions within the meaning of the act. The moment the Patent Act says following are not inventions, because patents are only given for inventions. However, if the act says following are not inventions and your invention falls within that part, then it gets rejected straight away as patentable subject matter, non-patentable subject matter. But if it goes through that filter, which is here, then you would put it through filter number two. And what does filter number two assess? It assesses whether your invention now is novel, whether it has an inventive step, and whether it is capable of industrial application. So these are things that we need to look at very, very carefully, that unless and until we do that, right? Unless and until you look at these two aspects, you will not be able to assess whether your invention is patentable. In the meanwhile, there is somebody who has asked a question: what if the invention is not patentable in India? Can we apply patent in any other country, in any other way or any country? Yes, that if that is not patentable in India, if it is not a patentable subject matter in India, but it is a subject matter patentable in any other country, you can apply in that country. On the other hand, if the patent office says this is not a patentable subject matter, then you'll have to argue with the patent office to say why it is a patentable subject matter and why you believe it is a patentable subject matter. So that was from Gupta Hani Rakesh. I've answered your question. I hope that is okay. Right? That is the answer to your question out there. Any other question? If the invention is done by a group of scientists, then how the person will be chosen? No, then the group of persons will be called person. So person, here in law, we call them as singular plural. So person also means persons. So I hope I've answered the question of Ritika Mujumdar. Okay. Suppose anyone patented one medicine and the other person wants to patent one medicine for the same disease, then I have not understood. So obviously, if somebody is already patented and you want to patent, you can't, because it's not novel anymore. So that is gone. Okay. And that was a question from Jui Datta. Okay. So I think whatever has come in the chat box, I've already responded to. So you can go on populating as we go along, and we will take it on from there. But for a different medicine, of course you can. But then you'll have to satisfy that whether it is called novel, whether it satisfies the inventive step, whether it's capable of industrial application, then you can. And we will take a few examples of that. What is the procedure? I'll come to later. Okay. Now, let me now spend some time, because this is a very important part. Let me spend some time on what these, that first filter, that in the Indian Patent Act, it defines the first filter as a list of inventions which are not patentable in India. And let us understand that first. So, we will look at it in technical terms. Okay? Forget the law part of it. But in technical terms, we need to understand. So, what does it say? Here it says, the starting says, what are not inventions within the meaning of the act? That means within the Patent Act, within the patent law, what are defined, which are defined that these are not inventions within the meaning of the act. And so, if your invention falls within that list, then it will not be patentable in India because it is not a patentable subject matter. So, let us look at that list. We will go through that list slowly, one by one, and we will try to look at various things. So it says that it's called a section 3 of the Indian Patent Act. And it says in the whole list, it starts with A to Q. We will go through that list. An invention which is frivolous or which claims anything obviously contrary to well-established natural laws. So suppose you come and say that I have an invention which is a perpetual machine, right? It's a perpetual machine. That means I have created a machine which, without giving any energy from outside or without itself generating any energy, it can go on running perpetually. Now you will not be given a, this is not considered to be, even if you come and say, oh, I did it. This will not. Why? Because you cannot have a perpetual machine. Laws of thermodynamics do not allow you to do that. And therefore it would be contrary to well-established natural law. And therefore that is not considered to be an invention within the meaning of the act. Then an invention, the primary or intended use or commercial exploitation of which would be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health or to environment, that will not be given a patent in India, because this type of invention is not considered to be a patentable subject. Let's take a few examples. Now, public order or morality. Suppose I invent a device, and I say this is a device or a very novel pickpocketing device. So I take this device, I go to a crowded place, I press a few buttons, and all your money automatically comes to me. It is a novel way of pickpocketing. A great machine, great invention. Will I be given a patent in India? Immediately patent office will come and say, oh, this is an invention, the primary or intended use or commercial exploitation of which is contrary to public order or morality. And because it is contrary to public order or morality, they will say this is not an invention within the meaning of the act. You have to be very careful in defining your invention and how this particular invention will be looked at. So very important. Similarly, which causes serious prejudice to human, animal, or plant life. So if you come with an invention which is a fantastic pesticide, but it kills all pests indiscriminately, then what will happen? If it kills all pests indiscriminately, you will cause a serious prejudice to the environment. In which case, that invention may not be granted a patent because it will not fall within the meaning of the act as an invention. Why? Because it causes serious prejudice to human, animal, or plant life. Or if you're working on stem cells and you say that I will derive the stem cell from the fetus, the moment you say I will derive the stem cell from the fetus, which is less than certain weeks, that will not be allowed in India. Why? Because that is like prematurely killing that particular fetus. In which case it would be against public order morality on one side. On the other side, it would be serious prejudice to human, animal, or plant life or health, or to the environment. You can now see, therefore, when you look at your inventions, you have to be very careful when you look at this list and what invention at your end. So the invention that you're doing, okay, whether that invention is going to be patentable or not patentable in India in terms of subject matter is going to be very, very important as far as we are concerned. Right? So this is something that we need to look at very carefully out there. Similarly, the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature is not patentable in India. It is not considered to be an invention. So if you come and say, I discovered the laws of gravity, or I discovered how the stars move, or I discovered how the atom splits. If I split the atom in a certain way, then that may be an invention. But if I come and say atom splits and therefore this is the theory, well, that would be a theory. Theories are not given patents. You can go and publish, but theory will not be given a patent. So scientific principle of formulation of an abstract theory, discovery of any living thing. So if I find a new animal, a new plant, a new microbe, then I will not be. Or non-living substance, I extract some genes. Those genes are existing in nature. I only extract. Can I get a patent for those? Even if others have not extracted it, answer is no. Why? Because it's a non-living substance occurring in nature. And then you will not get. Similarly, the mere discovery of a new form of a known substance, which does not result in enhancement of known efficacy of that substance, right? Or the mere discovery of any new property or new use of a known substance. Now we'll take this one by one. That if I find a new allotrope of either an element or a substance, I find a new crystal form. I go to nanotechnology and create new particles, particle sizes, distribution. Now, just because I did that, I will not get. Why? Because then I must show that it is not a mere discovery of a new form of a known substance, that it does not result in enhancement. So I'll have to show that there is a significant enhancement in properties with respect to what is already known of that other substance. Or it says that if I discover a new property, suppose you have a medicine and somebody has worked on it and says, oh, this cures headache. And I find that it can also cure stomachache. Same medicine. Nobody has found out. I found out. In India, you can't get for a second use of a known substance. In United States, you can, but not here. So the law says that if you're talking about the mere discovery of a new property or new use of a known substance, then no, you won't get a patent. The mere use of a known process, machine, or apparatus, unless such process results in a new product or employs a new reactant. So there are conditionalities that come into that. And this then becomes an important limitation in the Indian Patent Act. Therefore, you need to evaluate your work in light of this as there. Similarly, now we'll go further in the list. And that list says that a substance obtained by mere admixture, resulting only in the aggregation of properties of components thereof, or a process. That means what? That I take substance A, substance B, and substance C. I take, and the properties of A is known, property of B is known, property of C is known. I create a formulation of A, B, and C. Let us say in equimolar proportions, in which case it will become 0.33A, 0.33B, and 0.33C. So the total has to become 1 in the formulation. Now, if the property that comes out of this mixture is as if the property of 0.33 of A, 0.33 of B, and 0.33 of C, the property proportionately. And if they are doing that, that is, if the resulting only in the aggregation of the properties of the components, aggregation, then it will not be considered as an invention. Why? Because then it will say this is what is put in the Indian Patent Act and you cannot. Therefore, if I'm creating formulations, and even though nobody has created that formulation, it is very important for me to show a synergy between those components in the formulation. And only if I show synergy between those components, then only I will be given a patent and not otherwise. So mere addition or a mere admixture cannot be given a patent in India because it will not meet the criteria that has been put in this particular patent. So that is very, very significant as far as we are concerned out there. Now, then let us come to the next part. Next part is that, very important, the mere arrangement or rearrangement or duplication of known devices, each functioning independent of one another in a known manner. So I have 3 different types of devices. And what I have done, I've combined the 3 devices. Now nobody has combined them. And I combined the 3 devices. But then device A works on its own, device B works on its own, device 3 works on its own. Therefore, it's like a mere addition of A plus B plus C. I will not. So I will have to show that when I put it in combination, the device B and device A get correlated. So there is some sort of a correlation in function between device A and device B and device C. But unless there is some sort of a functional correlation between the 3, I will not be given a patent for that. I have to show that there is functional correlation. So therefore, when I'm designing my experiments, when I'm designing my work, I have to ensure that I establish those type of correlations. Now, method of agriculture or horticulture, which means if I come with a new method of plowing, and I say it's a method of plowing, I use the word plowing, then I will not be given. But if I say that, I have to change that wording in a certain manner, I may be able to get. Then another part, those who are working in the field of medicine, for example, okay, or so, any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for similar treatment of animals to render them free of disease or to increase their economic value or of their products is not a patentable thing in India. Now, what does this mean? Now, I invent a new injection, right? I also invent an injection, let's say, a syringe without the needle. Now, if I create that sort of an injection, the device can be patented. But if I say that I'm going to use the device and I'm going to do the injection on the human body, this act of doing the injection in human body is not patentable. Why? Because it will come into any processes for medicinal, curative, surgical, curative, prophylactic, diagnostic, therapeutic, or any other treatment of human beings or any process. So it will fall under that. So though the injection as a device will be patentable, injecting will not be patentable as a process. So that's why you have to be very careful in wording your inventions and seeing what it is. Method of surgery. And why is this put? So that doctors don't have to go and use that, oh, I'm going to use this method to do surgery. And then, should I go and take 10 licenses and permissions by the time my patient will be dead? So you can see that there's a lot of thought that goes into that sort of stuff. So medicines, you will patent. The way you will give the medicine, that you may not be able to patent because that would be an act on the human body. Acts on the human body will not be. Now, similarly, any process, diagnostics. Diagnostic. Now, when you do a diagnosis, in situ, you will not be. You do it ex situ, you will. So, you have to look at it that way. Therefore, the type of work we do, the way we design our inventions, the way we design our research, we'll have to work out what aspect we want to patent and what aspect we don't have to. So you'll have to think about all these things continuously. Therefore, this patenting area is a very, very intense. So when people like me go to do the evaluation of your inventions, I go into the nitty-gritties with you and check with you various aspects of these things. And that is how out there. So when I moved into this field of patents after 20 years of doing research and everything, I then moved into area of patents after that. And I've already spent about almost 30 years doing all this. But mind you, it is such an intense subject that it gives you immense challenges all the time because every invention is on its own to be evaluated, and therefore it becomes a great way of doing it. So you can't do patent work if you don't have sufficient amount of technical background, and only if you have sufficient technical background that you will be in a position to work in the field of patents. So that is something that we need to look at. For plants and animals in whole or part thereof. Okay, very important. Other than microorganisms, so microorganisms which don't exist in nature, you can get a patent. Now seeds, plant varieties, and species, and essentially biological processes for production or propagation of plants. Therefore, if you're looking at standard essential biological processes, the ones which are standard essential biological processes are not patentable. So suppose I'm doing work on, let us say, test tube babies. Then, so long as I am doing those aspects which don't get classified under essentially biological processes, that part I can patent. But if I take something and implant that into a human body, and then it happens in the human body, then that would be essentially a biological process. So that part will not get patentable, but the other part may be patentable. So you should be able to dissect your invention and look at all these things from that standpoint. You can understand that how intensely technical this subject is. It's not legal, it's technical. And therefore, there are very few patent attorneys in the country and around the world who understand each one of these to this level of intensity out there and to this level of clarity. So it depends on how you look at these. And unless you have that clarity, you can't get, write good patents in these particular fields. So that is that part. And then I come to the next part, and that is here, a mathematical or business method. Now, so let's carry on. So now the other part is a mathematical or business method or a computer program per se or algorithm is not patentable. So in India, what does it mean? If you just If you simply, are giving an algorithm, then a mere algorithm is not patentable in India. If you're talking about a business method, it is not patentable in India. If you give a mathematical formula, it is not patentable in India. But is a computer program patentable? It says a computer program per se is not patentable. So we must try and understand the meaning of this word computer program per se. So when is a computer program merely a computer program, that is a computer program per se, and when a computer program is not a computer program per se. So only if we show that I have got a computer program which is not computer program per se, then it will be patentable, not otherwise. So this is a challenge, a very, very big challenge. People who work in the field of computers and computer related inventions. Then obviously a literary, dramatic or musical work, all these are elements which go into the field of copyright, and therefore these are not patentable. A mere scheme or rule or method of performing a mental act or method of playing game. So today, if Sachin Tendulkar or Saurav Ganguli or let's say our any of the latest people, Virat Kohli, comes says this is the way you must do a square drive and patents that, then nobody can do that square drive. No, that is not done. Even though it must be a brilliant way of doing a square drive, okay, that is not a patentable invention in India. Why? Because the rule, so the law knocks this out in terms of this. Method of making a presentation, creating a PowerPoint slide or whatever, you can get a copyright, but you can't get a patent for it. Topography of integrated circuits is a separate law for topography. But if you say that I've created the integrated circuit and these are the functionalities, that can be patented, but the topography of that cannot be patented only because that falls into another different act. And this is a very important part now. An invention which, there's a comma there, invention which, comma, in effect, comma, is traditional knowledge. That means it is not saying that an invention which is in effect traditional knowledge. It says an invention, comma, in effect, comma, is traditional knowledge. So if that invention in effect is traditional knowledge, it will not be patentable. Now, how do you show that your invention is not in effect traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component or components? So here the issue is, for example, if you come and say that I, you know, how many of you know are, let us say, if you come and say that you are, for example, if you say that I am working on neem and I extract the neem juice and I create a pesticide or an insecticide using neem juice or extract of the neem juice. Will I get a patent for that sort of thing? Then the patent office may come and say that, oh, neem juice, pesticide, pesticidal properties of neem juice, all that is known. Therefore, we will not give you a patent for that. But if you show that you are extracting the neem juice, but you are able to stabilize that neem juice and you are able to enhance the biological activity of that neem juice, and if that is not traditional knowledge, you may be able to get a patent for it. Why? Because in neem, the azadirachtin, which is there, is very unstable. Very unstable. So if you've created some sort of a formulation where you have stabilized azadirachtin and therefore enhanced its biological activity with, by storing it and enhance the storage part, you may get a patent for that. So you can see that these are very important aspects of Indian patent law or Indian Patent Act. And therefore, I go back to my uh,
Hmm.
my slide where
Oh,
here. So here I come into this, and therefore the first filter is what I discussed today. If there are any questions on this, kindly
yes, sir.
ask your questions. Please ask.
Sir,
Yeah, go ahead.
you just told that if we can store it or enhance the biological activity of the name, we can get the patent. So people are working on DNA storage. Maximum people are working on, but with different material. So are those are patentable?
Yeah. Now, if you come about, first of all, if you are taking DNA
Hmm.
now and you say that this particular DNA is very unstable,
Okay.
and I have created a way of storing this, stabilizing this. So let's say if it's a configuration, and if that configuration is very unstable, right? And I find a way of stabilizing that configuration
Okay.
that may be patentable out there.
Okay. Thank you, sir.
Yeah. So ask any other questions because it's already getting to be 5 o'clock. So I would wait and I will not go to the next part. So what I did today was I looked at filter number one, and in filter number one, as a quick, as a quick, uh, you know, um, as a quick revision, we looked at that any invention which is frivolous or claims anything obviously contrary to well-established natural law, not patentable in India because it's not considered an invention. And we looked at very carefully into things that if there is any invention which is contrary to public order or morality, and we took examples, a few examples to illustrate that. We looked at mere discovery of new scientific principle, not patentable, for any living thing or non-living substance, certainly not. That means if you just extracted the DNA and say, oh, nobody has done this before, it is the pure form of DNA. No, or this is a pure gene, or this is a, I've spliced it, and this is the part, but that was already there. You won't. Now, the mere discovery of new form, I've given you that example, very clear out there. These are very difficult ones. Then I told you about the mere admixture, arrangement, rearrangement, rotation of known devices. So when you're working on instrumentation and you are combining different types of devices, you have to be very careful to show what is the sort of correlation between those devices which I'm putting together in terms of a, so what is the correlation, functional correlation between them? I have to bring those functional correlations out there. Otherwise, it will fall. Method of agriculture, horticulture, processes for medicinal, all that on human beings or on animal body is not patentable. Plant animals in whole or parts thereof, I said no. Microorganisms can be patented if you invent new microorganisms, but seeds, etc., all these get protected under a different law, which is called plant variety protection. You won't get a patent, but you can protect it under a different law. We will look at that separately. Mathematical method, we talked about, you have to look at what is the meaning of computer program per se. And if I can show that the computer program which I've written is not a computer program per se, now there's a lot of technical, uh, you know, meaning to all these words. We will go to that later, and the rest of it I've already explained to you. And the Q, an invention, which in effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditional component, are not patentable in India. So that is what I've done today. I looked at the filter number one. And so our lecture, the next lecture, which will be on 21st March, Monday, again 4 to 5, is where I will take this to the next filter. And that next filter, which we will do, will be looking at the concepts of novelty, inventive step, and whether the invention is capable of industrial application. But only if it goes to that filter, that one gets a patent. So we will look at this as well in the next lecture. So any questions at this stage, please feel free to ask.
Sir, can you hear me?
Please feel free to ask if there are any questions at this stage.
Hello?
Now, now it says, if the invention is not patentable, then can we use that invention in day-to-day life, or will it be prohibited? Well, you can use it on a day-to-day, yes, you can do that. Kindly give us an example where computer program is patentable. Very good question. Can I do this next time? I will do this part because this will take some time to explain to you out there. Now, sir, which body governs the laws of Indian Patent Act? There is our Ministry of Industry and Commerce. There is the Department of Trade, and Policy Promotion. So, it's called D.
It looks Professor Ganguli has become offline. Yeah, now it is there. Professor Ganguli. I think he has got disconnected. Yeah, it looks Professor Ganguli, his internet problem is there. Let's wait for a minute, then we can decide. It's already 5:06. Yeah. So the lecture is over. Professor Ganguli says the lecture is over. So see you on Monday. Okay. Thank you. All the best. We'll close the class lecture here.